Positively Michael podcast. Today is the first of what we hope to be mini podcasts with a very distinguished guest, Mr. Tom Mesereau. As we all know, Tom led the defense that successfully got Michael acquitted of all charges during the molestation trial, and he has very graciously offered his time and his talents to talking to fans during these criminal proceedings for Conrad Murray. We've gotten hundreds of comments about Tom, about you participating, and the fans are just so grateful that you're taking your time to do this for us, because it's really providing a lot of comfort and assurance that we're getting our information from the right place.
Well, thank you for the kind invitation, and I'm very honored to participate.
Oh, well, we are so happy to have you, so it really means a lot, so thanks a lot. Okay, we were just talking. Let's just go on and get this out of the way first. As all of you guys know that are listening, there have been some comments made recently that I think have been a little misinterpreted in the media, and I think that Tom is going to quickly just clear those up. So as we all know, Jermaine has a book coming out. Actually, I believe it was released last night. It's a memoir about Michael, and there are some comments in the media that stated that Jermaine had a plan to help Michael to escape to Bahrain if he was convicted. And as the lawyer, Tom has been contacted and asked to speak about the veracity of those claims. Tom, do you just want to go on and make a statement about that now?
Sure. Last Sunday morning, I received a call from Harvey Levin, the founder of TMZ. I've known Harvey for years. He's an attorney like I am. And as I think you know, he used to be the producer of a show called Celebrity Justice, where I was interviewed on some of my cases. Harvey wanted to know if I knew what Jermaine had said about a plan for Michael Jackson to flee the country. I said I had not heard anything about this. And he told me that Jermaine had claimed there was a plan in effect for Michael Jackson to flee the country to Bahrain if he was convicted. And I told him that I'd never heard of anything like that, and it sounded ridiculous to me because if Michael Jackson were convicted, he would not have left the courthouse. He would have been immediately remanded to jail. I was told years later by someone who was in touch with the Santa Barbara sheriffs that there was a great concern that there might be violence if Michael was convicted, and that they had a plan to bring him right through the courthouse to a helicopter and helicopter him to a federal prison facility where he would await sentencing. I mentioned to Harvey that Michael had always obeyed the law, that he had made every court appearance, that he came to court to accept the verdict, whatever it was, guilty or not guilty, and I just couldn't believe there was any such plan for him to flee the country. I also said that if I had ever heard of such a plan, I would have vigorously objected to it, that would have been my legal and ethical and professional obligation as an attorney to object to it and not participate in such a thing, because a lawyer cannot participate in criminal conduct.
Yeah, definitely.
And that would have been criminal conduct.
Yeah.
So Harvey then, published the articles an article with TMZ saying I called everything BS. I have since learned, because I bought Jermaine's book yesterday, that what he appears to be saying is that family members were at home and they were getting reports from me by telephone as to how the trial was going from time to time, and that if I ever told them that things were going very badly, that this plan might have been put in effect. He never says I knew about any such plan, which I didn't. And
right.
He never
or that
says
Michael knew about it.
He never says Michael knew about any such plan.
Exactly.
But what he says is that although things sounded horrible, I continually was optimistic, which I was. And that appears to be what he said, which is not exactly what I thought he supposedly said when I talked to Harvey Levin. But that's the way it is. I never heard of such a plan. I never even discussed such a thing with anybody. Michael never discussed such a plan with me. I have trouble believing Michael would ever go along with such a plan. He was a very law-abiding person, and as I said, he made every single court appearance, including coming to accept the verdict.
That's right.
So that's my reaction to all of that. I think Jermaine, from what little of the book I've read, it appears to be very well written. I must say he's very complimentary of me, which I'm very happy of and proud of, and grateful for. And it appears to be very well written, what little I've read. So I think Jermaine's heart is in the right place. He was always there supporting his brother, and he and I always got along. I did speak with him many times about the trial and how I thought things were going. He was very concerned about his brother's welfare, and I only have nice things to say about Jermaine.
Yeah, and I'm just really glad that you took the time to clear that up, because I think, you know, that's one of the purposes of us doing these sorts of interviews with you, is I hope that, I feel like that's been taking up a lot of media attention, and there's been a lot of court proceedings that have been happening. So I'm very glad you sort of made a statement. That's done. Thank you so much for clearing that up. And, you know, one of the ways that that's been leading or sort of linked into the court proceedings right now is because, as you know, the jury questionnaire was released to the public. And some of the questions that were on there, I mean, I'm hoping you can shed a little bit of light. You know, they had questions on there kind of saying, you know, do you think that celebrities in L.A. believe they're above the law? You know, do you feel like celebrities in L.A. get off because they're famous? And, you know, so number one, when those comments came out from Jermaine, I think a lot of people were very concerned that it would make the jurors think that Micheal was a part of that plot.
Well, I was a little concerned about that too, and I think it's very, very perceptive of you to raise that issue, because clearly the defense is going to try to devalue Micheal.
Absolutely.
They're going to try to devalue him in direct ways and in indirect and subtle ways. And they're going to try and make it easier for the jury to acquit their client by devaluing Michael Jackson, which I don't look forward to, but I know it's coming. Because I'm a defense attorney, and I know these people are doing their job, and they're trying to win. So I'm not looking forward to that part of the trial. It's going to be very disturbing for me, and I'm sure it'll be disturbing for many others. But I did have that concern, just like you did, when this issue surfaced.
I mean, so for the questionnaire, because that's something that's, you know, really been heavily discussed right now. Can you talk a little bit about the process? You know, to me, and obviously I'm not a lawyer, the way the questions are written, it seems like it'd be very easy to be dishonest just to try to get onto the jury. And I'm sure there's some sort of algorithm or process used to sort of, do a really good job of determining the veracity of the potential jurors. But can you talk a little bit about how that questionnaire leads up to the lawyers ultimately selecting the jury?
Well, a lot of so-called legal experts have been on television talking about the purpose of jury selection. And what they're saying is that the purpose of jury selection is to find an unbiased jury. And that's not really true. Each side wants to win. Each side wants jurors that they believe will be receptive to their argument, to their witnesses. They want jurors who they think will not be receptive to the other side's argument or their witnesses. And at its highest level, it's a very intuitive process. Unfortunately, many lawyers are not very skilled at trial work, and they're not very intuitive or sensitive to people. And I know that to be a fact, and many lawyers don't like hearing me say that, but I say it all the time. What happens is lawyers get educated in an ivory tower environment. They then work in ivory tower-type law firms. Many of them are disconnected from ordinary people or not interested in ordinary people. And suddenly they're in court and they're asked to pick a jury. Under certain circumstances. You know, you have a number of challenges you can issue without a reason. You can ask that certain jurors be removed because their bias is so obvious that nobody should have to use a challenge to remove them. They should just be removed for cause, is the word they use. And it's a process that follows certain rules. But each side wants a jury that they think will be, helpful to them. So in a high-profile case where there's so much media attention and so much potential for media bias, very often questionnaires are used to help that process because the lawyers are allowed to question individual jurors in criminal cases with the judge's permission. I think this judge has said the lawyers will have 20 minutes per potential juror to ask them questions.
Is that a significant amount of time? Or?
Not really. That's not much time at all, and that's the same amount of time that we had in the Michael Jackson trial.
Wow.
So to try and get more information about these jurors, these questionnaires are jointly put together between both sides and the judge. Each side contributes a questionnaire that they would like, and the judge decides what the ultimate questionnaire will be, assuming a judge is allowing a questionnaire to begin with, which in high-profile cases they usually do. Now, our questionnaire in the Michael Jackson trial was much shorter. The judge didn't want a lengthy one. This judge is allowing a lengthy one. I think it's 30 pages. or approximately 30 pages. Now, these questions have a dual purpose. The purposes are primarily to ferret out juror bias, to figure out, just where certain jurors are coming from by virtue of their answers. And also, the less obvious purpose is each side wants to ask questions that might influence or affect those jurors.
Right.
So a question like, do you think celebrities think they're above the law, will give someone some insight into what they think of celebrities. But I think it's probably also a defense question, where they probably want to influence the reader into thinking, do these celebrities really think they're better than everybody?
Oh, so I see. So the questions can also be used to influence jurors as opposed to really just trying to objectively see where they stand on things.
Yes, and I think that, lawyers are not going to necessarily admit that that's a primary purpose, but a question like the one you just showed me or explained to me clearly has that intention.
Right. Now, that is very interesting, and it does give, at least for me, it sheds a lot more insight about why they're asking the types of questions they're asking, because it does automatically kind of lead you to think, it does feel like a negative question. So that does make a lot of sense. There are several questions about the proceedings that a lot of our listeners and people on Twitter and all around have submitted. There are several that have to do specifically with the judge. And you're talking about the judge contributing to the jury questionnaire. This Judge Pastor seems like he's on top of, he's really not playing around with either side. He's
a very experienced, very bright, very smart judge. He's one of the best judges in that courthouse. He has tremendous experience as a judge in difficult criminal cases. Okay. And I think you have a very excellent judge in this case.
So I noticed, one of the things that one of our members brought up was asking if you could explain the reasoning behind why the judge would not allow Murray's possible motives for his behavior to be discussed, but they would allow the defense to reach back into Michael's history for evidence of drug use. So I know a lot of fans were thinking Murray's got his child support issues. He's got all sorts of, it seems from what the media has said, and again, we won't know this, I guess, fully until court, but he just seems, he's got several children out of wedlock, and they've sort of painted him as a Lothario that's not very responsible. And the judge said none of that can be discussed in the courtroom. But then,
well, I think the judge was correct on that. I think to bring in, Murray's having allegedly fathered illegitimate children or going to strip clubs or doing things of that sort, I think certainly would be very prejudicial to the defense. And their argument is that it might distract jurors from the underlying issues and make them predisposed to convict even if the proof isn't there. So I think the judge was trying to be fair to both sides in that regard. He's trying.
Here's the question, though, just to follow. Okay, so if they're trying to make sure that you're not biasing the jury, I guess what a lot of people are thinking is, if they know that Murray's having financial difficulties, like, for instance, in the Nevada case where he hadn't paid his child support in a while because he said he didn't have the money, what a lot of fans are thinking is, if you know you're going to be getting paid $150,000 a month to be Michael Jackson's doctor, you might be more willing to do things that are out of the realm of what a responsible doctor would do because you really need the money. So I guess that's the question is, if it's something that could potentially be related to...
Well, look, all of this is in the discretion of the trial judge, and judges go different directions. I thought it was outrageous, for the judge in Michael Jackson's trial to let in some of the evidence he let in of alleged motives by Michael to commit crime. For example, he let in the Bashir documentary.
Oh, yeah.
And the theory was that the Bashir documentary supposedly sent him into a panic and his career was going to be lost, and then he decided to commit crimes in order to respond to the potential damage of the Bashir documentary. I thought that was outrageous, but the judge let the prosecutors bring that in. He also let them bring in evidence of Michael's financial problems, claiming that those financial problems caused him to engage in a conspiracy to falsely imprison the Arvizo family, to abduct children, and to commit criminal extortion. If you think about it, it was just outrageous, but the judge let them bring in that information because they said they wanted to prove motive to commit a crime. Different judges will go different directions. But what happened in Michael's trial, quite honestly, is the judge accommodated the prosecution, and they unwittingly, in my opinion, helped us, because I think I was the only person on the earth, with the exception of Susan Yu. She agreed with me that Bashir documentary, on balance, was going to help us.
Yes.
Because the entire world media that wanted him convicted were focusing on these words, nothing's nicer than to share your bed with someone. They weren't looking at the rest of that documentary, which showed a child genius, growing into adulthood, showed his very intoxicating, wonderful dance and music, showed his naivete, had him saying that nothing sex happens in his room, had him explaining why he settled the case in the early 90s, and also, because that documentary was allowed to be played, we were allowed to show the outtakes that were not included in that documentary.
Oh, yes.
And that showed how Mr. Bashir was tricking him with various trick questions, how he was not being honorable with him. And also, Michael at one point said, I'd slit my wrists before I'd hurt a child. And
yes, he did.
I think on balance it helped us, although the prosecutors thought it was going to bury us. Additionally, the evidence of his financial problems showed that all of these alleged co-conspirators were taking advantage of him.
Right.
And it made Michael look more like a victim, although the prosecutors thought it would make him look like a desperate criminal. So sometimes you got to be careful what you wish for. You may get it in a courtroom.
Right. And, and that's actually another question that one of our members, Renee, pointed out. She was asking, do the different sides have to get the arguments they're going to make approved by the judge? Like, for instance, I think you've probably heard that the defense is trying to allege that Michael, woke up and basically either drank propofol or put it in his IV, and they've sort of, raised all of these, they've sort of like thrown a lot of different possibilities out there to sort of, and in my opinion, and again, I'm not a lawyer, but it seems like they're just trying to get them out there and see which ones resonate with the public. And some of the things seem like they're so ludicrous that it would honestly be a distraction from the case. And so I think what she's asking is, how does the judge determine, this is just so far off base, I'm not even going to allow this to be discussed, or does he sort of let everything go and then just leave it up to the prosecution to make objections? No,
I think both sides will try and raise certain issues in advance and ask the judge to not permit the other side to either present evidence or to make certain arguments. And different judges will go different ways. It's a very human process. I think clearly the defense in this case is trying to throw a lot of things at the wall, hoping something will stick.
Yes, I agree.
And even if the judge lets them argue in their opening statement that he drank the propofol, if there's no proof that he drank it or no reasonable inference from the evidence that he drank it, he may not allow them to argue it in closing argument. For example, in the Casey Anthony trial recently, the defense argued that Casey Anthony, the defendant on trial for allegedly murdering her daughter, alleged that she had been sexually abused in the opening statement, but in the closing argument, the judge would not let them argue that because no evidence had come into the trial supporting it. So a trial is a very fluid, uncertain process. Different judges go different ways on whether the relevance of something, assuming it's relevant, is outweighed by the prejudicial effect against either side, and it's somewhat fluid and somewhat unpredictable. I think that my sense is that this judge is trying to focus on the underlying issue. The underlying issue is, did what this doctor, did to Michael Jackson rise to the level of a crime? In other words, did having propofol in that home without proper assistance, without proper equipment, result in criminal conduct? That, to me, is the fundamental issue. And I think the defense was hoping to dirty up Michael by bringing in evidence from the molestation trial and bringing in evidence from what other doctors were prescribing. And I think this judge wisely saw through a lot of that as nothing but a smokescreen and a diversion and an attempt to distract the jury from the underlying issue. To me, the question is, did this conduct rise to the level of a crime? And I believe it did.
Yes, absolutely. And so, keeping in that same frame of mind of thinking about this being a crime, I always wonder how, number one, as a defense attorney, it's got to be difficult. I mean, I'm thinking about Murray's lawyers right now, and I'm wondering, I've always wondered if they truly believe that he's innocent. And, it's interesting because it's come out, this has been said multiple times, but it's come out recently that, they keep saying that Murray doesn't have any money, he can't pay, like they've made comments saying, well, the prosecution's got all these great experts and we just can't afford that. And so there are two parts to this question. The first one is, do you think they're doing this pro bono? If so, why would they be doing that? And then the follow-up question that one of our moderators, Krillian, pointed out, which I think is a really interesting question. She pointed out the defense has publicly said, they don't have the money to pay for experts. They've complained about Judge Pastor multiple times to the point that he had to say in open court that he did not want them commenting to the media if they were upset with his rulings. And they've just made claim after claim. Is it possible that the this could be a strategy for them to ultimately want to get a mistrial?
It could be. It could also be a strategy to raise issues in the record for purposes of appeal if he's convicted.
That they're just saying that things weren't fair, throughout the entire process.
Well, there's a general rule of law that if you don't make an objection to something, you can't raise it on appeal. So what happens is a lot of defense lawyers will constantly object to all kinds of things just to make sure the objections are in the record in the event of an appeal. Now, that can cause some other problems because too many defense attorneys, in my opinion, have it sort of beat into their subconsciousness that they're going to lose. So they're already preparing for the appeal before, the verdict's even in. And I always tell people I try cases to win in the trial. I don't try them for appeal. Right. I won't raise issues sometimes if I think it will make me look less credible and look like an obstructionist. It's a very delicate art how to try a case, and you're balancing all sorts of different considerations. But look, the defense lawyers are professional criminal defense attorneys. They're doing their job as they're obligated to do. Their ethical and professional obligation is to vigorously defend their client. You're not allowed to break the law in the process, but you must vigorously represent and defend your client. Everybody in this system is supposed to work hard and be aggressive. Otherwise, the system doesn't, work as well as it's meant to work. Now, as far as money goes, my understanding was that Conrad Murray was continuing to work as a doctor so he could pay some of his legal bills up until the beginning of the trial.
That's initially what was said, but now that Ed Chernoff just did an interview and said that Murray's broke.
He may be broke. We'll never know because it's confidential what, if anything, they've been paid. I don't know if insurance money has been available for any of his expenses. But you ask why would lawyers do it pro bono, and I think the answer to me is pretty obvious. They're going to be on television. Yeah, I mean that's what we were all thinking. But of course, when he was asked that question, I think he sort of said, "Oh no, he hasn't ever." I've never heard him come out and say, "I firmly believe that he's innocent." That I'm sure he probably has said that. I just haven't seen it anywhere. But I know that he's definitely been making a very big deal in interviews about the fact that Murray doesn't have any money, and also that he doesn't have access to the same level of expert that the prosecution will have. I don't know if that's true or not. I just don't know the answer to that. Yeah. I don't know who he's talked to, and I don't know who these experts on his list are or what they're, allegedly going to say. I really don't know.
Do you know, I mean, this might sound a little off, but just on that same line of the financial questioning, so back when they were looking at Murray's medical license in Nevada and they had that court case, the way that they were trying to take his license was basically saying that he was behind on child support payments. And Murray said, I don't have the money, I can't pay this. And someone, it was never revealed who, paid all of his child support payments. And so I think there's been a growing concern amongst a lot of the fans that he's got some benefactors or someone that might be paying his legal bills. I mean, I guess there's no way you would probably ever know that. But
no way I would ever know that.
Is that common, though? Would that be common for a high-profile defendant to have people helping him financially?
I mean, it happens, I mean, he may have patients that he, think he treated them very well in the past, and they may be rising to his defense. I just don't know. Yeah. I don't know Conrad Murray, never met him. I don't want to meet him. And I'm, pro-prosecution in this case. I'm hoping to see a conviction. But is it possible someone has tried to raise money to help him with his defense? Sure. Yeah. I mean, and I think it seems like that's pretty clear, but no one has actually come right out and said it when they've been asked about his financial situation, so I think that makes sense. Another question that we've gotten is, how do you think, especially based off of your experiences with Michael's trial, how do you think that the media's influence will help or hurt this trial, both for the defense and for the prosecution? And that's from one of our members, PYT. It's very hard to tell. because, I just published an article in one of the legal magazines for new lawyers, and the subject is how to handle a high-profile or celebrity case. And I tell them that there's a tremendous, media industry in the United States and in the world that you have to think about as a lawyer because they can conceivably affect the jurors. But I also say that if you get too carried away with that, you will lose focus on the 13 most important people, the judge and the jury. And you also, because you're in front of the camera, will be tempted to lose focus on who's most important, and that is your client, not you. So, and I also have a very strong belief in the integrity and individualism and character of jurors in the United States. They're not always correct. There is injustice because no human beings are perfect. But if you look at a number of high-profile trials where the media said there would be convictions, you'll see the media being wrong. O.J. Simpson, Robert Blake, Michael Jackson, Casey Anthony. These were high-profile trials where the media overwhelmingly said there's going to be a conviction. And the jurors acquitted. Jurors look at things very differently than we do. Okay? They are under oath. And they are in that courtroom 6 to 8 hours a day, and they see, hear, and feel everything.
Right.
There's nothing that happens in a courtroom that at least one or two jurors don't pick up. If one juror is not noticing, someone else is. And they are repeatedly reminded they are under oath, and they are also told they're under oath to follow the judge's instructions to them before they go to deliberate. And they will be read a series of instructions as to how they're to interpret the evidence and how they're to, interpret reasonable doubt. And jurors take the job very seriously. When they go into that jury room to deliberate, and they start walking out for breaks, you'll notice a very different look on their face. They're very serious. They're very focused. They're very determined. And I think this jury can decide what's right no matter what way the media goes. Now, in the Michael Jackson case, you had an avalanche of media from all over the world that was terribly negative about him. It got so ridiculous that during the week that the jury deliberated, in America they were showing jail cells on the various networks every day.
Oh, my God.
In my opinion, it was designed to influence the jury. They were showing on the cable stations just the jail cell, where he'll be, what his schedule will be like, what kind of a life he'll lead. I thought it was absolutely outrageous. But nevertheless, and I didn't want the jury sequestered because I think a sequestered jury is a very miserable, unhappy jury. And at the beginning of that trial, we thought it would last 7 to 8 months. It actually only lasted close to 5 months because I cut back on the witnesses we could call because I felt we were doing very well, and I felt I wanted to get that to the jury now, rather than put them through another few months of possible misery. But nevertheless, I had faith in the jury process, even if the media was negative, and it turned out that we did fine. I'm not concerned about the media influencing this jury either way. I think they will take the judge's instructions very seriously, and I think they'll do what they think is right.
Do you think it was, so it sounds like from what you said, you do think it was the right decision not to sequester this jury?
Well, I can argue it both ways. Okay. It's not going to be as I said before, I thought Michael Jackson's trial would be 7 to 8 months, but this is supposed to be 5 weeks. So, yes, it would be an imposition, but it wouldn't be as great an imposition as, say, O.J. Simpson, where the jury was sequestered for 9 months. And apparently they were just miserable. They were not allowed to watch certain TV shows. They were given newspapers with certain articles cut out. They were followed by, the sheriff's department. I mean, apparently it was just a miserable experience.
Right.
But I had a sequestered jury in a death penalty case in Bessemer, Alabama years ago. It went for 3 weeks, and they did fine for us as far as I'm concerned, and they, didn't seem to be too overly miserable. We were in trial every day, including Saturday. The judge wanted us to have trial on Saturdays because he didn't want to imposition the jury and make this, too long an experience. But I have faith in this system. Now, I can see why the defense wanted them sequestered because they just watched Casey Anthony walk free on the most serious charges, and that jury was sequestered. But it's in the judge's discretion, and he said, it's too expensive and not necessary, and I think any higher court would have held him on that.
Do you think, well, you were just mentioning they think this trial is going to last about 5 weeks. Do you think that sounds about right, or do you think that sounds,
Well, that's what I've been told. I'm not involved in the case. I'm not privy to either camp. So only they know what they're thinking in terms of strategy, witnesses, et cetera. But my understanding through people in the media I've talked to is they're talking about 5 or 6 weeks.
Okay. So another question that came up was about the discovery phase of the trial. And I remember Ortho Diva is asking, what information must be shared? Is it statements, background, intended relevance to the proceedings, for the different witnesses? Like, how much does each side have to put out there before the trial begins?
Well, generally speaking, in state court in California, the defense gets all of the police reports. They get all the interviews of witnesses the prosecution plans to call. They get all of the reports by any experts the prosecution plans to call. And the prosecution is under a duty to provide to the defense anything that is exculpatory, meaning could contribute to the innocence of the defendant, or is potentially exculpatory, meaning it has potential for contributing to the innocence of the defendant. And arguments go on over whether something is really exculpatory or potentially exculpatory. My general experience is that although some prosecutors are unethical and unprofessional in this regard, that rather than avoid a problem on appeal, they will give you, most of their information or all their information. Police reports, police interviews, expert witness reports, forensic examinations, that kind of thing. And if they plan to call a witness, they have to give you any statement of that witness. Now, the defense also has to provide the prosecution with any statements of any witness they plan to call that they have, and also any reports or findings of any expert they plan to call. So generally, the prosecution has to give the defense more than the defense has to give the prosecution, but the defense has to give information to the prosecutors or they can be precluded from calling witnesses. If I'm going to call witness A and I have a statement from that witness, I have to give it to the prosecutor. If I'm going to call an expert on a particular matter and I have any notes the expert took or any reports the expert made or any conclusions the expert made, I have to give that to the prosecutor as well.
Gotcha.
I hope I'm not sounding too technical. I don't mean to.
I actually think it's great because it's really helping to put everything, in the appropriate context for what we've been hearing in the media. I prefer when you're technical, actually. I think most of the listeners will.
Okay.
One of the questions that came up from another member, Betsy, is she's asking, I think we all know that you've said multiple times that juries are usually reluctant to convict the physicians. And she's asking, do you have any rationale for what the reasoning would be behind that? And also, is this based off of statistics regarding convictions that you know about for physicians?
No, this is based on my general experience and observation. People like to believe in their physicians. All of us as human beings, like to look up to somebody.
Right.
And, we would like to believe that our doctors are very skilled, very intelligent, very experienced, and that their heart is in the right place. We know that often isn't the case, but we like to believe it is the case. And my experience and my observation is that unless there's very compelling evidence that a doctor committed a crime, many jurors don't want to accept that the doctor did. Let me give you an example. Elvis Presley. Elvis Presley's doctor was just giving him inordinate amounts of dangerous medication, and frankly, it killed him. And if you were to look up the amounts of medication that Elvis was getting from his physician, you'd be horrified. The prosecutors put him on trial for manslaughter. They went to trial, and the first jury hung. They couldn't agree. A mistrial was declared. They had a second trial, and the doctor was acquitted of manslaughter, despite all of this horrendous information about just mountains of pills he was giving Elvis. Subsequently, the medical board in Tennessee stripped him of his medical license, and he ended his life, as I understand it, working, I think, in a UPS store in Tennessee. So there's an example of a doctor who, frankly, should have been convicted of a crime and wasn't. I mentioned that when I was first asked, what do you think of the charge? Because I know that fans around the world and the family wanted a murder charge, and I understand why they did. Emotionally, I can understand why anyone would be so appalled at what this doctor did that they would want a second-degree murder charge. I was very cautionary about that. I said, look, I think that a jury is not likely to believe that he wanted this. A jury is not likely to believe that he intended this. In fact, a jury is likely to believe this is the worst thing he wanted, that this has opened up Pandora's box and is his worst nightmare. And I think that if they had charged murder, that would have allowed the defense to argue to the jury that these prosecutors are abusing their power, they're pandering to the media, they're pandering to the fans, you can't trust anything they're doing, they've abused their power to the point where they have no credibility, and you would give the defense a better opportunity to see him walk out of there. So that's why, even though I realized that not everybody liked what I said what I felt the truth was. I want this man convicted of a felony. I want him stripped of his medical license. I want him punished for what he did, because in my opinion, based on the information I have, he thought he had, won the lottery when he met Michael Jackson.
Oh, yeah.
He thought that he had just hit the jackpot, so to speak. Mm-hmm. And that suddenly, from being in debt and having all kinds of financial difficulties, he was going to get $150,000 a month. He was going to live rent-free in a beautiful mansion in Beverly Hills, California, mm-hmm. and he was going to be the physician on the biggest comeback in the history of entertainment in the world.
Yep.
And he was tantalized by all of this, and my opinion was that he was going to do nothing to jeopardize it, even if it meant putting Michael Jackson at risk.
That's right.
And I believe that's what happened.
Oh, absolutely. Absolutely. I mean, I couldn't have said it better myself. That is the perfect summation of, I think, how the vast majority of us feel right now. And I agree with you. I think at this point in time, nothing would be worse than for him to get away with murdering Michael. And so getting a felony conviction is, I mean, if it can be gotten with manslaughter, then I think that is obviously better than, as you're saying, charging too high.
Well, look, you just saw the Casey Anthony verdict. People were shocked that she was acquitted of the most serious, criminal charges. Mm-hmm. And many people think she walked free on those serious criminal charges, which involve murder and manslaughter, because they overcharged the case.
Yeah.
Many people think they should not have been seeking the death penalty. That was a message to the jury that they've not really used their power properly. And many people think if they'd only charged a lesser type of offense, she would have been convicted of something more serious. Wow. And I, as a defense attorney, have used the notion that prosecutors have abused their power and overcharged a case to acquit clients. So I know what they would likely do. I know what I would do if I were defending them, which I never would.
Yes. Yeah, no, absolutely. I mean, I think that, I don't know, I would just like to point out, too, that also just really speaks to your character, like you just said, that you would never defend him. I've never understood, when there's cases like this, how, like I was saying earlier, how a defense attorney can represent him unless, it truly is just about the attorney being on TV or raising his or her own profile.
Well, let me rise to the defense of my profession. I have to do that now because I'm often asked, would you defend a person you thought was guilty? And the answer is yes, I would, because my job is twofold. One, to see innocent people acquitted, and two, to make sure that the system works properly.
Is that it's fair.
And, if I make the system work properly, I feel that I've accomplished something. And everyone in America is presumed innocent till proven guilty.
That is true.
And everyone has the right to a vigorous defense attorney. Now, sometimes people are guilty of something, but not what they're charged with. Sometimes people are guilty of a simple battery, and the prosecution comes out with attempted murder and abuses their power, even though they're going after someone who very likely might be guilty. So I am a great believer in making the system work. But in this case, particularly, I was Michael's lawyer. I have the greatest affection for Michael. He was one of the kindest, most sensitive, most decent human beings I ever met. He was a joy to represent. He was kind. He was considerate. He was gentle. And unfortunately, in many ways, fame killed him because he ended up with enablers like Conrad Murray, who would tell him anything they thought he wanted to hear to stay involved. But I would never defend him because of my relationship with Michael, because of my sympathies to Michael, and I just wouldn't get involved in that case. But I want to make clear that I'm a defense attorney, and I believe in my profession.
Yeah, of course.
And
that's what I was going to say. I'm obviously biased here because...
Well, of course you are. Of course you are. I understand that. But, this system doesn't work unless everybody does their part. The judge, the prosecutors, the defense attorneys, the jurors, the witnesses, everyone must do their part for this system to work properly. Right.
Now, another question, I think we'll probably wrap up after this so we don't take up too much of your time. Speaking about the charges and trying to make sure that we can get a felony conviction with Murray, a lot of fans are asking that if, God forbid, he is not convicted, will the Jackson family be able to sue him in a civil suit for wrongful death or anything like that if he's not convicted?
Yes. I mean, the civil process is totally separate from the criminal process.
Okay.
Criminal cases involve whether or not someone will be convicted of a crime and whether or not their freedom and reputation will be affected. They're not generally about money. Civil cases are generally about money, about money and property. So to convict someone in a criminal case, you must prove guilt beyond a reasonable doubt. To win a civil case, you must prove liability by a preponderance of the evidence, which is a much lighter and easier standard. They're totally separate processes. In the O.J. Simpson case, he was acquitted of murder, and then he was found liable in a wrongful death case, and I think the verdicts were like $35 million. So the answer is yes, they're separate processes.
And I mean, obviously, if you can do it if he's not convicted, then I guess if he was convicted, the answer would obviously also be yes, that they could still go after him.
Yes, they can civilly, assuming they file the case on time, and assuming they follow the right procedures in civil court.
Right. And I know that, there has been this wrongful death suit that was put out a while ago, but I know there's been several problems with the filing. There's been lots of components of it that have had to get taken off and amended and things like that. So I guess we'll see how the case that's already out there progresses separately from the criminal trial.
Sure. Now, very often civil cases like this are stayed, meaning they're essentially frozen until the criminal case is resolved.
Gotcha.
And I suspect that's happened here, but I really don't know. I'm not in those cases.
Yeah, but that's actually, I think that would make sense, and I think it would also, make it sort of less distracting for the criminal proceedings as well. Sort of keep it all focused.
Well, in a criminal case, if you're a defendant, you're under no compulsion to testify.
Right.
In civil cases, you can be forced to testify. So typically, to preserve your right not to testify, they will freeze the civil case till the criminal case is resolved, and then they'll reopen it.
Oh, I see. Oh, that makes sense.
Okay.
You have just been a wealth of knowledge.
Well, thank you very much. I appreciate the opportunity to talk to you.
Clearly, this is your profession because you are so fluid and so well-versed in all of the law, and this is exactly why we wanted to do this. You've been wonderful.
Well, it's been my pleasure, and I'm honored to answer your questions, and hopefully we'll talk some more.
Yeah, definitely. And I know I speak for all of the fans when I say, yet again, thank you so much for taking your time. And to all of the fans, as you see, Tom is incredibly gracious with his time. If you guys have got specific questions, please send them to us on positivelymichael.com. You'll see a thread in the investigation section specifically to submit questions. You can also tweet them to us. Our Twitter is @PosMike. Tom, thank you so much for your time. We will share this with the fans immediately, and we're looking forward to talking to you again in the future.
Same here, and my best to everyone. Thanks so much.
Thank you.